Welcome back. I'm here with Kerry Kiernan. He's a candidate for Court of Appeals, and we were engaged in our conversation about how you started out and everything. This is a great way for individuals to get to know who you are and stuff. So they see the name on the ballot, and like I said, I was explaining to you earlier. Talk a little bit more about I know you went into public defender's office. I think we could take it from there.
Right.
And then
I went into private practice,
Correct,
right?
yeah.
And we had one of the most interesting cases I had was a big personal injury case, the Shuttlejack case, which was a Shuttlejack bus accident where a bunch of Santa Fe students were on the bus. And we represented a family with a father who was one of the chaperones was killed and the boy was hurt. And so there were about 38 plaintiffs in that case in addition to us, and there were many defendants, the Shuttlejack Company, the Santa Fe ski area. And it was an interesting experience because our firm basically helped broker a settlement of the case, and we were the lead plaintiff's firm. So we had to work not only with the defendants, but had to work with the plaintiffs on our side to try to figure out a fair division of injuries.
This was an accident, correct?
An accident, yeah, a
Okay,
Shuttlejack
so-
bus
correct.
accident. The brakes had failed, and the bus had crashed, and as I say, I believe there were two students who were killed. We represented one student and an adult who were killed. We represented the adult and another student who was injured. Another lawyer had the other student's family. But it was an interesting experience because you had to negotiate with both sides. You had to negotiate with the defendants for a settlement, and you had to also bring together the plaintiffs because we thought that we could try to settle the case. And again, this goes back to my theme of the people really wanted a just and fair settlement because nobody wants their case tried in court if they can avoid it because it takes so long. And I think lawyers have to have that sense that the best thing they can do to be the most effective lawyer is to get their client through this as quickly and expeditiously and fairly as possible.
And
judges
was
have
this
to
a
have-
very long, drawn-out case?
It was,
took a- I think
it was a long case because of the nature of trying to work with all of the defendants and all of the plaintiffs. But we managed to avoid a trial, and we worked on a global, what they call a global settlement involving all of the parties. And so that was very interesting because you got to know personalities, you got to know how to negotiate, you got to know principles of law. We threw out some new principles of law, created some new principles of law in that case. And so it was a very interesting case in that regard.
Was there another case that you worked on had to do with malpractice or had to do with physician, doctor, or something to that effect? Is that
I've had some physician cases, yeah, in the past, yes, yeah.
so? When you're looking for cases, was there a specific thing that you look for as far as your appeals background?
You mean whether to take a case
whether to accept the case or not? Was there something that?
When I'm doing an appeal background, it's really if it's an interesting legal issue, or I think that the person, didn't get a fair shake, possibly below. Those two things will guide my considerations. And on a general case, when it comes in, it's usually, how interesting is the case, or how badly was the person hurt? Does this person need legal representation? If it's a commercial dispute, you study the contract and you understand whether or not you have a good faith reason to go forward. So there are many different considerations depending on the type of case it is.
So since you have an appellate background, are you able to ascertain right at the beginning, at the onset, whether what the direction of the case would be by looking at the certain details? I'm trying to figure out how it affects you as far as an appellate background when you're looking at a case.
You mean when a case first comes in?
First comes in.
Well,
this is just for the law students.
That's right.
Yeah.
It's interesting because the first thing you think about is what are the evidence problems that I'm going to face in the case, and how are those going to stand up on appeal? What are the legal issues? Can I overcome some legal issues? And even if I overcome them in the trial court, will the appellate courts overturn or affirm the trial courts? So yes, I'm thinking of how is this going to play out on appeal? Because
so there's got to be a valuable experience there to have that appellate background. Right?
Well,
as far as
hopefully for the appellate court it certainly is, but when I take a case in, it's also valuable, as you point out, because I'm looking at it not just from what would happen if we win a trial, but what would happen next.
Yeah, because they could appeal it on this and this.
They could appeal on this and this and this, and so you have to study the strength of the case from that perspective. Now, a lot of lawyers will call me during the year who are trial lawyers and will get my advice even as they're approaching trial on how to make sure that their record's going to be complete, that they've preserved what they call preservation, make sure they've presented all their issues to the district court so that the appellate court will hear those issues. And that gives me a great, it gives me a great satisfaction to be able to help trial lawyers get through that process. And then after the case is decided one way or the other, they will come to me and ask me to help them with the appeal. But you're right, that background has been very important.
Very important. In going back to the Court of Appeal, since you're running for that, there's I think, division in there as far as mediation. Explain to those watching, what is that mediation? How does that work? As far as, does it just go into mediation first before it gets to the judges? Or?
Yeah, I think most of the civil cases now, there are certain cases like criminal cases which are not mediated, but most of the civil cases will be referred to the mediation
Do they
office.
automatically go into mediation first before they go?
But usually you'll get a letter that this case is in mediation after you file. And so the head of that, Mr. Rambo, will then notify the parties that the court wants to try to mediate the case. And sometimes those cases are in fact mediated on appeal, saving the parties, of course, a great deal of money. I don't remember the
Because it's very
percentage of
expensive
cases.
to go into.
It is.
So it saves a lot of.
And that's a relatively, not all appellate courts across the country have that, so that's a relatively good thing. Now, that the parties don't always settle, don't always mediate, but at least that service is, provided for them.
Does it become difficult? Now, this is a separate question. Does it become difficult when you have a lot of special interests coming in as far as appellate courts? Does it make it difficult on the judges as far as deciding the cases? Because you're dealing with special interests there, have a huge amount of interest in the state or different parts of the state. Does it make it different when you're dealing with oil and gas and things like that? Does it make it difficult?
Well,
I know the judges have to be very fair.
They do.
I
And
understand. That's the first.
when I was clerking for Judge Reed, we talk about those things, but ultimately it really did depend on the facts and the law. And every judge I knew up there at the time, it really did depend on the facts and the law. And so I can't say that, a special interest would, steer a case one way or the other.
Yeah.
And I would assume the same is true of the sitting judges on the Court of Appeals. My perception is that they look at the law, they look at the facts. And I would assume that special interest problem is much more prevalent, for instance, with the United States Supreme Court, because there the issues are so mercurial, if you will.
Because the highest court, we see issues coming up there. Yeah.
But I think the judges here understand that their role is, and the role of all judges, is impartiality, and you must look at the record before you. You can't, make up facts. You can't make up the law. You have to be fair to the litigants in front of you.
And I think a majority of the judges that I know that become judges are usually very fair-minded person. I mean, most people are. I don't think you can be a judge unless you are fair-minded to begin with, I think. Is there anything that you can think of that would benefit a law student looking into going into appellate? As far as appeals, and they need to be good in research, right?
They need to be good in research.
Yeah.
They have to persevere in research. I mean, it's an interesting thing. Computer legal research is
It's very different, though, from just normal general research
right.
of any kind.
But computer legal research has come in, and in the last 20 years or so, and many students in law school now. When I was in law school, that wasn't the case, but now there's computer research, and they learn on that. But I find that young lawyers sometimes don't go to the next extent, even though they're very facile on a computer. And they know about the principles, they don't have the experience to say, I wonder if I were to change my search inquiry, if I'd come up with another answer. And I'd say to law students, don't give up. If you're not finding something, think of another way to approach the problem. And I'd also say to law students, get as much writing experience as you can from writing courses in law school.
Right.
A lot of new lawyers come into the firm, and the one thing they think they know how to do is write. And believe me, they don't. When you're writing as an advocate, it is imperative to be clear, concise, and argumentative. One time, Judge Hartz on the 10th Circuit Court of Appeals was doing an appellate seminar, and he said to people, don't try to be eloquent, don't try to be, like the great justices, just be clear. And I would tell all law students in their writing, and all lawyers, be direct, concise, and clear.
So that's what differentiates a good.
That's what differentiates a
Like
good
your
judge
average, yeah.
and a good appellate advocate. Clarity, because to be clear means you have to understand the problem. It's like when a scientist is discussing a very difficult scientific principle, the ones who know it best can teach it best.
Explain it better.
Explain it better.
And it depends on their own research. Yeah,
and you
correct.
can't ever lose that ability to be clear, concise, and direct. And I would like to think that I could bring that to the Court of Appeals.
I think so. When we come back, I'm going to take a short break, about 30 seconds away here. When we come back, let's talk a little bit about how the electronic age has changed how research is done.
Sure.
I think that's an interesting way
Sure.
of kind of educating people.
Right.
Okay, we'll take a short break. We'll be right back.